Welcome back, everybody, to our studies in jurisprudence. In this lesson, we're going to take an introduction to the next of our major topics, this one being an investigation and a study and an examination, if you will, of legal positivism. What we'll do in this lesson is essentially introduce, which is something that arguably one of the most important of the theories of jurisprudence, at least of the last century or so, given the fact that, as I've mentioned in previous lessons, specifically looking at modern natural law theories, that the introduction of legal positivism sort of usurps the growing popularity of natural law. Natural law seems to wane in terms of its popularity going into the 20th century, especially so as well because of some of the horrendous events which takes place in the early 20th century. Things like the Holocaust, things like the horrors of Nazi Germany and Soviet Russia and even communist China. And so, as a result of which, there is a less of an interesting amount of support and defense for the view that law is inherently tied to some kind of objective morality and natural and a natural law theory, especially given the fact that it was law and legal systems that can allow things like the Holocaust to take place in the first place. So that was one of the reasons why natural law theory sort of falls off a little bit, but legal positivism arguably usurped natural law theory a little bit earlier than that, in the late 1800s and into the early 1900s. So that's why I've said here that it is arguably one of the most important theories of jurisprudence in the last century or so. It is incredibly influential, and any series of lessons that looks at jurisprudence will spend a lot of time examining legal positivism. We'll take an introduction to the subject of legal positivism in this lesson. We'll outline the structure of the lessons that we're going to be doing on legal positivism, but we'll also talk about some of the main and early considerations that we can sort of get out the way straight away before we start to look at the various different varieties of legal positivism. Before we start to talk about Austin and Bentham, and we can talk about Hart, and we can talk about, for example, Dworkin and all these different people who have engaged in conversations and debates about legal positivism. So let's just very quickly and very easily define what legal positivism essentially is. Now, because this is a philosophical theory of law, of course it's not necessarily easy to just define legal positivism using a simple dictionary definition, for example. Instead, we'll talk about what legal positivism is, looking at the etymology of the phrase and looking at the way in which it was derived from the Latin. But then we can also talk about what some of the main considerations of positivism are and how positivism differs in some ways to natural law. And so rather than coming up with just a single one-sentence definition of what legal positivism actually is, you can sort of situate your understanding of legal positivism in conjunction with your understanding of natural law theories, something that we looked at in previous lessons. So the word itself, positivism, derives from the Latin positum, and it is, broadly speaking, refers to this idea of law being laid down, or specifically, as you might understand, law being posited. And so legal positivism essentially argues that the validity of law's validity and the acceptance of certain laws is determined objectively with reference to some verifiable source. We will talk about what this verifiable source ultimately is. People like Austin and Bentham argue that it is deference to the sovereign, for example, a sovereign authority, that they create the law and the law becomes valid and the law becomes correct owing to their creation of it. It is objectively defined by some verifiable source. It rejects the natural law view that the validity and the existence of the law, almost the ontology of law, can be determined externally to human nature. And so when we talk about the idea of natural law theories, we posited, at least with some of the earlier interpretations of natural law, people like Augustine and Aquinas and even Aristotle to an extent, they argued that there was this idea of an objective law of nature, which is a sort of a moral code as well as a legal code that we can defer to. And people like Augustine argued that there was this difference between the eternal law, the law that is passed down by God through biblical revelation and scripture, and the positive law, the law of man, the law that is created by human beings, and that it is only valid when it is in conjunction with and aligned to this eternal natural law. Positivism, of course, rejects this view. Positivists also reject a number of other things, the majority of which would reject the idea that law and morality are necessarily connected. Unlike natural law theory, which is not only a theory of law, but it is also a theory of ethics, of normative ethics, and also a theory of morality, legal positivism does not accept this view, that there is an inherent connection or a necessary connection between the idea of law and the idea of morality, the idea of moral philosophy and ethics. Now, as I've mentioned in previous lessons, again, this is not necessarily going to suggest that a positivist does not take into account morality at all in their considerations, that morality is not mentioned and is completely and wholeheartedly rejected as a consideration for any kind of legal argumentation, but only that it will exist on the periphery of a positivist's argument. In reality, positivism does not think about morality in the same way as natural law theories do. Natural law theories really place the concept of morality and moral philosophy front and center in their considerations of what makes a law just. Now, one of the reasons why this is particularly popular, especially in the early 20th century, is because, of course, it became difficult to reconcile law and morality when it was legal systems such as the Third Reich that actually led to things that we would argue are wholeheartedly immoral, things like the Holocaust and the Second World War. And so this idea that law can be and is inherently legitimate if it is moral and adheres to some kind of moral law, the natural law, was rejected on the basis that people were trying to argue on the one hand that there was a legitimacy of the law in the Third Reich. At least it was in and of itself a law and a legal system, but it was something that perpetuated some of the grossest and most heinous immoralities that we've ever seen in human history. So that's one of the reasons why there was a sort of rejection of this inherent connection between law and morality in the early 20th century, and more of an acceptance of a sort of morality blind view of the philosophy of law, view of jurisprudence. It also seeks to separate the legal concepts from things like sociology and history, and any kind of sociological or historical interpretations of the law, which we'll get to in future lessons' time, are not to be factored in any meaningful way in this discussion. Again, just like with morality, however, a positivist does not necessarily oppose the use of sociology and history as examples, or even as making some kind of subsidiary arguments. But the idea of them being central in their considerations is something that is rejected. And we'll get to how society and historical interpretations can actually influence legal theories in the future when we talk about people like Durkheim and Max Weber, and we talk about people like Karl Marx looking at historical and sociological theories of law. But for now, when we talk about positivism, the idea of sociology and history is not necessarily important for our considerations. While we're going to get onto the positivism, the origins of positivism in the next lesson, it should be noted that we're going to begin looking, when we start to look at the key figures and the key thinkers within legal positivism, we'll begin with the works and the likes of people like John Austin, and also John Stuart Mill. Now, the final thing I want to do before we start to outline the next few lessons is to talk about this connection, or should I say a lack thereof, a distinction that is made between the idea of what ought to be the case and what is the case. So looking at how positivism interprets normativity. So one of the most important things that a positivist will avoid and seek to avoid is the idea that their considerations are not focused on what the law ought to do. From any kind of perspective. I've written here from a moral perspective, but from any kind of perspective. Moral perspective is obviously the easiest to understand because the idea of something ought to be something else is often viewed through the lens of morality. So positivism does not look at the oughts. It doesn't look at what ought to be the case. It doesn't necessarily take a view on what is morally desirable in the structure and content of the law either. It instead looks at what the law is, not what the law ought to be, and makes a clear distinction between these two things. What is and what isn't law is different to what ought and what ought not be law, okay? These are different things. We'll get to what these things mean in future lessons. So finally then, let's just look at the structure of these lessons as we go forward in the next few weeks. We're going to be taking a look at a number of different legal aspects of positivism. We'll talk about the origins of legal positivism, the kind of foundations and the key foundations in the history. So we'll talk about some historical developments, looking at the developments of things like revolutions in the 17th and 18th centuries, and the development of legal positivism in conjunction and almost as a response to these different kinds of overthrowing of sovereign authority of the monarchies. We will then start to look at Bentham and Austin, looking at Austinian positivism before we look at more modern theories of legal positivism, more accepted theories as well, looking at the works of people like H.L.A. Hart, and then we'll talk about some of the responses that were levied against people like Hart with the works of people like Ronald Dworkin and his interpretations of legal positivism as well. Welcome back, everybody, to our studies in jurisprudence. In this lesson, we are continuing talking about legal positivism, and we're going to focus on the idea of its historical development. Now, this isn't going to be a particularly in-depth or even that much of a long lesson, particularly, because ultimately, we see that legal positivism develops out of the sort of mid to late 1800s, and we will get to some of the more classical theories of legal positivism in the next few lessons, namely working on the concept of the writings and the work of people like John Austin. And then we will start to get into the more modern debates about legal positivism, of course, coming from philosophers such as that of H.L.A. Hart, and then the responses to positivism from the likes of individuals like Ronald Dworkin. But in this lesson, we'll just talk about some of the situations and some of the ideas and some of the theories that existed at the time in which legal positivism was starting to gain a little bit more momentum. And then really just as a background, an idea of the context in which legal positivism begins to develop. If you remember back to earlier lessons, we remembered that one of the things that happens in the development of legal positivism is a decline in natural law. And the decline in natural law takes place in a number of different ways. You have, of course, the secularization of society more generally, because of the fact that natural law is inherently tied, or at least historically has inherently been tied to religious fervor. So, for example, the writings of Augustine and Aquinas. And of course, with the secularization of society, you will see a sort of a decline in that kind of religious influence over legal jurisprudence. But also, we see the development of atrocities that take place under the remit of what is perceived to be legal systems. So the legal system of the Third Reich, you have the legal system of the Soviet state, committing atrocities against their own people and against others. And this sort of leads people to turn away from this general idea that morality and law have an inherent connection, given the fact that you have a system which is inherently a legal system in the Third Reich, for example, but that is and cannot ever be a moral system. And so you see a decline in natural law for that reason as well. But at the same time, and sort of developing concurrently to this decline in natural law, you see the growth in the concept of legal positivism. So this is going to be more of an introduction to the classical forms of legal positivism, their theories as well as their critiques. And I want to begin with the works of Blackstone, because Blackstone is very, very interesting in his interpretation of how the common law is described within the English legal system, because it is seen here that the principles of the common law are almost transcendent. And this is something of a natural law position, because just like Plato believed that principles such as justice and beauty were transcendent ideas, and you sort of have to look towards the idea, the Platonic theory of forms, for example, to have an understanding of these ideas. Blackstone believed that the common law was and inherently had basic principles which had these transcendent characteristics, these transcendent ideas attached to them, which is something of a natural law position. And what is interesting here is that a rule in the common law, a view of the common law, and the development of the common law by judges is not the creation of new rules or the idea of the invention of new ideas and new principles of law. It is instead described as the discovery of new principles. According to this understanding of law and jurisprudence, at least during this period, and specifically applied to that of the common law, the idea here is that the common law exists as it is and has always existed, almost as a transcendent principle, or at least the principles within the common law are transcendent in a similar way to Plato's understanding of justice and beauty, for example. And that when judges develop new rules for the common law and they come up with new judgments, they are not inventing these judgments. They are discovering new rules of the common law that had already existed, but that just human beings had not yet discovered. This is a very natural law perspective, okay? And it is to say essentially that the common law already exists. All the rules already exist within the common law. It is for the judges to discover them rather than to invent them. This was the dominant position and the dominant theory for the majority of both philosophers and legal theorists for the majority of the 1800s. Remember what I said, the concept of legal positivism comes out of debates that take place in the sort of mid to late 1800s with the work of Bentham and Austin, and then we go into the 20th century. So for the majority of this period, at least for the early 1800s and going into even the later 1800s, this sort of position that is ascribed by individuals like Blackstone is the majority held view. The idea of principles of the common law being transcendent in and detached from the workings of the legal mind, and instead are discovered by the legal mind. They are not developed by the legal mind. Now, this is sometimes described as a theory of natural law as common law. It's almost a way of trying to conjoin the two ideas together, and for English common lawyers to try and understand the common law through the lens of a natural law perspective, and almost to essentially repeal and replace natural law with the idea of the common law, while holding some of the basic principles of the natural law, the idea of objectivity, the idea of morality, the idea of transcendent idealism in relation to concepts and theories of legal principles. And so that's what the dominant position was. And so with this in mind, and with the context of this being established, we start to see the beginnings of challenges. And the concept of legal positivism, at least today and in the 20th century, the latter half of the 20th century, is seen to be the dominant position, at least this sort of new, improved idea of legal jurisprudence. Today, you obviously have a bit more influence from some of the social theorists and critical legal theorists, but for the most part, legal positivism and positivism more generally is something of an established viewpoint within academia. And so when we start to see the challenges of the of legal positivists, or challenges by legal positivists, we begin by thinking about the political developments in the revolutionary situations of the 18th century, the 1700s. So in the 1700s, you see a number of revolutions take place. You see the French Revolution, you see the American Revolution. The century before, you see the English Revolution, with some of the political writings being developed out of that, being quite influential in French and American revolutionary thought. So one of the major critiques of revolution more generally is the work of individuals like Thomas Hobbes and his publishing of Leviathan, which is a anti-revolution document, essentially. It is a document which essentially tries to explain why one ought to submit to a sovereign authority, to a monarch. But with these new revolutionary ideas and with these new developments in both the French and American revolutions comes new ideas such as the rights of man, as well as fundamental freedoms and liberty. People like John Locke begin to have more and more influence within political philosophy. The same for French philosopher Jean-Jacques Rousseau has, again, more and more influence in the liberal thought processes and the development of liberalism in this classical age. But one of the areas where we see further challenges as well is in jurisprudence and with the origins of some of the theories of the concept of legal positivism. These pose significant threat to the concept of monarchical authority. And so we start to see in the late 1800s the work of John Austin, who is arguably, in conjunction with Jeremy Bentham, the originators of the ideas of positivism that we know of today. The legal underpinnings of legal positivism come from some of the revolutionary works of John Austin. Austin was also a revolutionary in his development of a theory of law, and one of the things that really set Austin apart from the conventional wisdom of the jurisprudence at the time is this idea that law can be separated from morality. Within Austin's framework of legal positivism, we see the concept of law is derived from the concept of the sovereign, not necessarily from the concept of morality. There is no transcendental idea of law. There are no transcendent set of legal principles. There is no discovery of legal principles in the same way as Blackstone's understanding of the natural law as common law. And so understanding this idea is quite revolutionary in terms of the break from the natural law theorists going towards this idea of deriving law out of sovereign authority, not out of morality. We'll get to this in more detail in future lessons' time. In the previous lesson, what we did was take an introduction to legal positivism in a little bit more detail, exploring and examining the general context in which legal positivism begins to grow and gain in popularity. We talked about some of the historical developments of the common law as natural law. So one of the theories being that the common law had in it, and as part of it, fundamental principles which were transcendent, in a very similar way to how Plato used to argue, when he was alive, how Plato used to argue that things like beauty and justice were transcendent ideas. We also took a look at the work of Blackstone in a little bit of detail, focusing on the idea that according to the common understanding of the common law as a natural law theory in the mid to late 1800s, the concept of a new principle of the common law was not one that was developed by lawyers or new theories and new ideas as applied to new facts. Rather, it was discovered by lawyers. There is no such thing as inventing new concepts within the common law according to these basic ideas. There is instead discovering new principles of the common law. We also talked about the fact that as natural law began to decline as a result of a number of different things, it wasn't one thing particularly. There was the impact of the Second World War on the one hand. There was also the sort of growing shift away from very religious and religion-oriented theories of both politics and of philosophy and also of law, with the sort of general secularization that came with the wave of the Enlightenment. We see the beginnings of a shift in the development of legal jurisprudence away from this concept that law is inherently tied to morality and instead separating those two concepts, law and morality, which is what legal positivism essentially does. This is not to suggest, however, that there is not a single theory of legal positivism that doesn't take into account concepts of morality. There are, of course, ideas that link with morality, but essentially, in rejecting natural law, the legal positivists understands that law is not inherently derived out of morality and is not inherently linked to morality. In this lesson, we're going to talk a little bit more about the traditional theory of legal positivism, focusing on the theories of Austinian positivism. We'll talk about Austinian positivism in this lesson. We'll talk about one of the major critiques to Austinian positivism, this being the idea of international law not being considered law, which is, of course, a theory that I certainly reject personally. So, as a general recap, legal positivism originates from some of the revolutionary works and some of the revolutionary theories of law from the works and from the likes of people such as John Austin and people like Jeremy Bentham. John Austin was a revolutionary in his development. He believed that you can develop a theory of law which was separate to that of morality. There was a separation between law and morality in this way. And within this Austinian framework, we can see that the concept of law is not derived out of morality. Instead, the concept of law is derived out of the sovereign. So what John Austin essentially does is he takes the view of law and morality and replaces morality with this idea of sovereignty, this idea of the sovereign within the concept of legal creation. And what this essentially does is, because the sovereign is a tangible thing, it's often, at least when we talk about monarchies, a person, or it could be a parliament, or it could be any other kind of legislature. This essentially taking away from ethereal concepts like morality and applying instead concepts like sovereignty, which are much more concrete. They actually represent a person or an institution. What we do is we get rid of this idea that there are transcendent sets of legal norms and principles. So, according to the Austinian positivists, there are no transcendent set of legal norms that exist in the same kind of way of a natural lawyer, and how a natural lawyer would understand the concepts of the development of law and the interrelationship between law and morality. So the Austinian positivist is revolutionary in this regard, rejecting the basic principles of law and morality as being inherently tied to each other, which maybe today is not too much of a controversial opinion, but at the time was relatively revolutionary. And so legal positivism is the rejection of basic principles of a priori logic. So what this essentially tells us is the same kind of a priori reasoning that natural law depends on to exist is rejected by the positivists and the Austinian positivists specifically. So a priori is an epistemic mode of understanding knowledge, essentially. So epistemology is the philosophy of knowledge and the ways in which we understand knowledge and how we derive knowledge and our justifications for believing certain actions and certain things. A priori knowledge or a priori reasoning is reasoning that requires no external empirical evidence. Okay, so you can understand something and you can derive conclusions about things a priori if you can do so using your own rationality, your own reasoning, your own logic. And then you have the almost the opposite, the polar opposite to a priori logic or a priori reasoning, which is a posteriori reasoning, which relies on external empirical evidence for things. Okay, so for example, a classic example is that I could say that all triangles have three sides. This is a statement, a proposition that is either true or false. I can conclude from my own a priori reasoning that this is true, because I know that a definition of a triangle is a shape with three sides. So to say that something is a shape with three sides and saying that that has three sides, which is what essentially the proposition is tautological. It is obviously true. It is a priori true. I don't have to go out and empirically measure every single triangle that exists in the universe to try and measure to conclude that they have three sides or not. That's not how I would come to that conclusion. I could do so from sitting in my room, and I can logically deduce that that is the case. That is an example of a priori logic or a priori reasoning. This kind of reasoning, this kind of understanding, is something that is relied upon within natural law. For people like John Austin, the most important thing about law is that it determines the condition of its own existence, okay, rather than requiring this a priori reasoning. It means, therefore, that there are no external factors upon which law relies on its own basic existence. Now, in concluding this part here, I want to just make it very clear that one of the major critiques of Austinian jurisprudence is its relationship with international law. Now, international law was not as prominent as it is today when Austin was writing, but you may come to the conclusion that if law is derived out of the sovereign, then what about law that has no sovereign? What about law that does not exist in relation to any kind of sovereign authority? International law is not derived out of sovereign authority. So by sovereign authority, we're talking about, for example, state sovereignty, the sovereignty of a state. That can be represented as a monarch, as a single individual, as a dynasty, or it could be represented as an institution, like a parliament or a legislature. And so international law doesn't exist in that same way. And so as a result of which, this is a problematic aspect of the Austinian positivist theory, should I say, not natural law theory, is that Austinian jurisprudence depends on the existence of a sovereign to create law. As a result of that, international law doesn't exist, or at least international law isn't law, according to the Austinian positivist, because there is no sovereign authority, there is no international sovereignty that exists. So as a result of which, how can an Austinian positivist conclude that international law is law? This is not to suggest that international law doesn't exist according to an Austinian positivist. That there is a collection of things that we can describe using the phrase international law, but according to an Austinian positivist or someone who believes in Austinian jurisprudence, this thing that we call international law, we can call it international law all we want, but it is not law in the same way as domestic legal systems develop law. Now, this is not even an uncontroversial opinion in some realms of academia, specifically within common law jurisdictions. There are lots of common lawyers who do not believe international law to be law, not necessarily because of this particular justification, but just generally because it is different to the domestic systems in terms of enforcement and in terms of the ability to apply said law. That's a general critique of international law, but this is quite interesting how an Austinian positivist, since it derives, an Austinian positivist will derive their understanding of where law comes from the sovereign. The concept of international law cannot exist as law in the same way, according to this kind of positivism. In the previous lesson, what we did was talk about Austinian positivism, some of the major component aspects of Austinian positivism, a basic recap of some of the early and traditional concepts within legal positivism, and then the major critique of John Austin's legal positivism, which is of course his reaction to and relationship with international law, given the fact that according to Austinian positivism, law is derived from the sovereign, whatever that sovereign may be, and given the fact that international law is made without the existence of some kind of international sovereign, it's suggested that therefore international law is not law. It may still exist, but it is not law in the way that we understand domestic law, for example. Well, what we're going to do in this lesson is go into far more detail looking at Austin's definition of law. We're going to talk about some of the elements of Austinian positivism. We'll talk about some of the key components of it and some of the very specific elements of it as well. So far, we have been examining the nature and origins of legal positivism, the jurisprudential theory of legal positivism. We know already that legal positivism is something that has developed from the sort of mid to late 1800s with people like Bentham and people like Austin, and then develops further post-Second World War, and now we have some of the more modern legal positivists, people like H.L.A. Hart, and then you have the sort of Hart and Dworkin debates that were had in relation to positivism and jurisprudence more generally. But for now, let's just focus on some of the classical theories, some of the traditional legal positivists. The origins are in the work of John Austin. So given the fact that what we did in the last lesson was essentially delineate between what is natural law and what is legal positivism, I want to actually get into some of the specifics relating to Austin's definition of law itself. So we talked about where law comes from as part of Austin's theories of law, but what about his definition of law? So what then actually is law according to legal positivism? So according to Austin himself, law is, quote, established in an independent political community by the express or tacit authority of its sovereign or supreme government. That is the conclusion that Austin derives when he thinks about what law actually is. And this is interesting because we're talking about the express or tacit authority of its sovereign or supreme government. Remember, the last lesson we focused on the fact that law is derived out of the sovereign, according to John Austin. And this is obviously different to the fact that there is an inherent link between law and morality, according to natural law theorists. And so you establish law either impliedly or expressly through the authority of the sovereign or a supreme government. And this gives rise to what Austin describes as sovereign command theory. This is the theory that law derives out of the sovereign authority of the state. And it's a simple extension of the thesis of Austinian positivism. It's a simple extension and logical conclusion that you can derive out of thinking about what John Austin believes in terms of his understanding of legal positivism. In its simplest form, it is the sovereign command theory is the proposition that the law is at the command of the sovereign. Okay, as the name suggests, sovereign command theory, it suggests that the sovereign is in command of the law itself. Okay, and this again forms a basis of this particular quote, this particular passage, the idea that law is established in an independent political community, either expressly or impliedly, by the authority of the sovereign. It implies that, therefore, it is the sovereign that is in command of the law, the proposition that law is at the command of the sovereign. And with that being said, and given that fact, it also is extended. The next extension is that there are no external influences which impact on law except through that of the sovereign. Not only is sovereign command theory telling us that the sovereign has command of the law, but it is telling us that only the sovereign has command of the law. There is no other external influences on the law. And the key distinction delineation that we always derive here and we always point to is the idea of morality. Morality is not something that is influencing the law and the creation of the law. Only through the sovereign is their influence and creation of law. That is the point of sovereign command theory. The next general principle of Austinian positivism is known as the separability thesis. Okay, and again, this sounds quite fancy and academic, but in reality is very, very simple, just like sovereign command theory. Because what the separability thesis tells us is that it's essentially the assertion that distinguishes positivism, legal positivism, from the natural law theory. Because essentially, what the separability thesis tells us is that law is dependent on nothing else for its existence than the command of the sovereign. Okay, so remember what I said here earlier on, talking about sovereign command theory, that there are no external influences and that it is the sovereign that commands law, and then I also mentioned that it is only the sovereign that commands law, that there are no external influences. Well, this is explained and exemplified in the separability thesis, because what this is telling us is that there is nothing else that law depends on for its existence than the command of the sovereign. So long as the sovereign commands it, that's how law is justified, how the existence of law is justified. There is no concept of justice, there is no concept of fairness, there is no concept of equity, there is no concept of anything like this, or morality as well, if we want to include that and distinguish to natural law, that influences the law. Okay, that is not to suggest that these things don't exist. It is to suggest that these things don't influence law, because it is only the sovereign and the command of the sovereign that influences law. So bear that in mind, because of course John Austin was writing at a time where things like equity existed, at least as legal concepts. Equity existed and has existed for nearly 1,000 years in the common law system. But it's not that they don't exist, or that you can't derive justice out of some legal principles, but it is just that justice, fairness, equity, morality do not influence the law. Austin wouldn't suggest necessarily that there are laws which are not moral or that don't align with morality. It is just that they are inherently distinct. Okay, if they align with morality, that is because the sovereign commands it, not because they have to. There's a prerequisite that they have to align with morality, or that they are influenced by morality. Law is only influenced by the command of the sovereign. So, command of the sovereign plus sanction are the core elements of law in Austinian legal theory, and essentially when we think about this, how do we think about this in relation to the enforcement of law? Because the will of the sovereign is not necessarily the only aspect of Austinian positivism. It is the only influence and the only point in which law is derived, but it's not the only aspect, okay? Because what Austin also does is place emphasis on the importance of law enforcement, enforcing the law. Actually, there's a difference between actually thinking about the law and thinking about what the law is and how it ought to be and how it should be made, and then also thinking about how we then apply that law to real-world situations. This takes us from the realm of the academic to the real world. And there ought to be a mechanism in place, according to Austin, that exists for law to be enforced. And this is, according to Austin, exists in the form of the institutional enforcement of law. So things like the police force, a police system, a judiciary, a military, etc., etc., all of which play their role in applying the law and enforcing the law, because it is the police who do the sort of day-to-day work of ensuring that the criminal law is adhered to and investigating those who do not adhere to the criminal law. It is then the judiciary to then make a judgment as to whether or not the police have been correct in their decision to charge an individual with a particular crime. In certain very extreme circumstances, a state can be put under what is known as martial law, where a military then takes hold and sort of enforces the law as applied by in military situations, in situations of emergency often. So when we combine both this idea of sovereign command theory and the idea of enforcing of the enforcement of law, we get what we believe to be we form the notion of law according to Austin.